May it please the court, my name is Michael Hellens. I appear on behalf of accused number 2, together with my juniors, Mr. Zakwe, Mr. Relani, instructed by Mr. Masenya of the attorneys Masekela Masenya. We're ready to proceed with the application. We have no interpreter requirements whatsoever.
Mr. Rutland, you confirm that you don't need the services of an interpreter? Thank you. You will then proceed. Mr.
Before that, from the last time we were here on Monday, there is just an amendment that we effected to the annex in the charge sheet. We included the fifth count there. If you look at the charge sheet, it goes up to count 4. There is count 5. I did this morning. I was indicate that to my donors friends, and I supplied them with a copy of the new annexation. That will reflect the count 5. May I hand it in your worship?
Mr. Mugil, do you confirm what the prosecutor says that following the additional charge being added, you have provided with the details of that?
We confirm we've been provided with this amended charge sheet this morning.
So then you prepare on the basis of the totality of the charges as they are?
We are. Thank you.
Thank you. Mr. Helen, you also confirm that you were...
Yes, a copy was given to my junior, but it doesn't affect accused number 2. It's only against accused number 1.
Thank you.
Making copy of the signed affidavit.
Thank you. We then proceed with the heads. Mr. Wilkins.
Your Worship, yes. I confirm that it is my instructions to proceed with the bail application on behalf of the first applicant by way of affidavit. Which affidavit has been prepared, been duly signed and commissioned. May I hand up the affidavit to enable Your Worship to follow as I read it out?
then proceed.
Thank you, Your Worship. Your Worship, the affidavit reads as follows. I, the undersigned...
I just want to understand it, Madam Affidavit is not going to supply us with a copy to follow the proceeding.
You have an extra copy for the state.
I provided him with a copy, Your Worship. I permitted.
Just clarify the press situation.
So another point that we are whispering about is the fact of the media that does the court allow, as last time, the order of the court as last time is still the same.
I have, because I wasn't presiding during the application, I got it from my brother who was presiding that the order was that the officials' visuals, the court officials must not be depicted on show. And that order stands, it is not changed anywhere. So I just hope members of the media are aware of that. Anything contrary to that, we must to order from contact.
Now, I appreciate it.
As it please the court, Your Worship. Your Worship, it reads as follows. I, the undersigned Julius Dr. Mkhwanazi, do hereby make oath and say that 1. I am an adult male employed by the Ekurhuleni Metropolitan Police Department, hereinafter referred to as the EMPD, as the Deputy Chief of Police and reside at number 22 Eugene Murray Street, Randhaag, Alberton. 2. The facts herein contained are, unless otherwise stated, or unless the context otherwise indicates, within my own personal knowledge and belief, and are both true and correct. 3. Where I make statements of a legal nature, I do so on the advice of my legal representatives, whose advice I reasonably believe to be correct. 4. I'm a South African citizen, the first applicant in the above matter, and the first accused in the main proceedings, and this is an application for my release on bail. Your Worship, at paragraph 5, I'm reminded by my legal representatives, and which reminder I find encouraging, especially having regard to the considerable attention that this matter has attracted in the media and with the public, of the words of our former and late Chief Justice, Justice Ismail Mohammed, in the matter of State versus Atchison, 1991, Volume 2, South African Law Reports, 805, an Namibian court decision, where our esteemed former Chief Justice remarked as follows. An accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will, therefore, ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. I pray that these words resonate with the presiding officer, seized with deciding the fate of myself and my co-applicant in this bail application. Paragraph 6. From the paucity of information that has been provided by the state to my legal representatives, it appears that I have been charged with fraud, defeating or obstructing the administration of justice, and corruption. Given that I have not had any access to the docket and am thus not able to make complete submissions in respect of what may be averred by the investigating officer, especially in respect of the state's objections to my release on bail, I reserve my right to seek leave to respond to any aspect that requires a response after the state has presented its case in opposition, and to the extent that it may be prudent to do so. 7. The state alleges that the offences for which I have been charged falls within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977. 8. I am further advised that the determination of the applicable schedule is a matter of law, and that my legal representatives may advance legal argument in the Honourable Court disputing the correctness of the state's contention that it is a Schedule 5 offence. This notwithstanding, this affidavit has been prepared on the basis that the provisions applicable to Schedule 5 offences find application. I respectfully submit that in this affidavit, I more than adequately discharge the onus of proving that the interests of justice permit my release on bail. 9. I am presently unmarried and reside at my aforementioned address with 4 of my children. The property is registered in my name, and I have a bond with Standard Bank Limited. I have resided at this address for the past 7 years, previously having resided at number 161 Sidwana Crescent, Forslorus, extension 5, Katlong, Ngala section, which was my marital home. 10. I was born at the Natalspruit Hospital and grew up in Katlang, Gauteng. I attended primary school at Kumalu Primary School. I later attended high school at Lutukula High School, where I eventually matriculated in 1997. After matriculating, I participated in various youth development programs throughout Ekurhuleni before gaining employment with the EMPD in about 2003, initially as a cadet. Following my employment with the EMPD, I have attended various skills development and training programs, which includes inter alia, a military leadership life skills course, a military leadership development and communication course, and a specialized police weapons training course. 11. Academically, I have obtained a master's degree in public management from the Genesis Business School, Sandton, Gauteng. I have also attended various other academic courses at Wits University and the University of Cape Town. 12. My parental home is situated at number 728 Manana Street, Mavimbela, section Katlang, Gauteng, where I formerly resided with my father Julius Mkhwanazi, my mother Florence Zwane, and my brother Lawrence Mkhwanazi. My father passed away on 28 June 2009. My mother is a pensioner and still resides at my parental home. My brother resides at number 299 Nala section, Katlang, Gauteng. We are an extremely close-knit family. 13. I was previously married to Ethel Baliki Yali. We were divorced in about 2017. There are 3 children born of our marriage, namely 2 daughters, Kawekazi Mkhwanazi, Kanya Mkhwanazi, and 1 son, Nhlopito Mkhwanazi, aged 19. All 3 of my 6 children reside with me at my home in Alberton. I have 5 other children born from previous relationships. A daughter, Ekurhuleni Shabangu, aged 31 years, who resides with me at my aforementioned address. Late mother, Zanele Shabangu, is late. A daughter, Lesedi Ramasunya, aged 19. She resides with her mother, Ntabiseng Ramasunya, at 7834 Tolp Street, Leondale Gardens, Germiston. A daughter, Leletu Mhlapi. She resides with her mother, Nonsikilelo Mhlapi, at number 14 John Deere Street, Eden Park West, extension 1, Alberton, Gauteng. A daughter, Buhle Bombelo Mtsiba, aged 14. She resides with her mother, Cynthia Mtsiba, at Unit 43, Cricklewood Complex, George Street, Mubatan, Gauteng, and a son, Penyu Masupi, aged 11. He resides with his mother, Bongani Masupi, at number 5 Corners, North Rand and Trigger Road, Boksburg, Gauteng. Although my 4 children in subparagraphs 8.2 to 8.5 above do not reside with me, we share an extremely close relationship, which includes me seeing and spending time with them on a regular basis. They often visit me at my residence and spend quality time together with me and their other siblings. I also contribute towards each of my said children's expenses and maintenance on an ongoing basis. 15. I have a valid passport that was issued on 18th August 2025. I have not used my passport since it was issued. However, I have previously travelled abroad on holiday and made use of my old passport. My passport is available for handing in if need be. I do not have any close relatives nor friends who live outside our country's borders. I consider Gauteng to be my permanent home and, indeed, has been my permanent home since birth. I submit that I have a long-standing and deep-rooted ties to the Gauteng community, both social and familial. Because of my strong ties and familial roots to the broader Gauteng community, I submit it is highly improbable and indeed impossible that I will avoid standing my trial hearing. I further submit that I have good and stable family support structures. 16. Through my employment with the EMPD, I earn a monthly salary of approximately 65,000 rands a month after deductions. I do not have any other sources of income apart from my said monthly salary. I am the holder of a bank account with Standard Bank account number 002209099636. 17. My assets comprise, inter alia, my home, which is worth approximately 2.5 million, and in respect whereof Standard Bank is owed about 2 million rand. I have household furniture and effects which are fully paid and worth approximately 300,000 rand. I have been employed with the EMPD as stated above, since 2003 and am due a considerable amount of pension of around 7 million rand. I'm aware that if I flee, I would stand to lose all these benefits and assets. 18. My health. I'm of ill health, having been diagnosed with type 2 diabetes in about 2021. I am on chronic medication to manage the said condition and other general ailments, which medication includes Colson, Zandas, Asvapor, Tendiap, Dalramet, Omiflux, Trepeline, and Curicos. My attending physician is Dr. Koenie Venter, who practices out of HealthWorks Medical and Dental Centre in Boksburg, situated at Shop 14 East Rand Retail Park, Wolfrand Road, Everly, Boksburg. Dr. Venter can be contacted on 011 306 1300 to confirm any aspect related to my medical history and treatment. Previous convictions and pending cases. 19. I have no other criminal matters that may be said to be pending against me, nor do I have any previous convictions. To the best of my knowledge, there are no warrants of arrest issued against me that remain unexecuted. 20. There are no protection orders, whether in terms of the Domestic Violence Act 116 of 1998 or the Protection from Harassment Act 17 of 2011 that have been granted against me. I confirm that there are no applications for such protection orders pending against me in any court. In addition, I am not currently subjected to any interim protection orders, nor am I bound by any conditions arising from such orders. The charges, arrest and defence. In paragraph 21, I was arrested in my residence on Saturday, 18th April 2026 at about 4 o'clock in the morning by a contingent of police officers that comprised around 6 vehicles and 9 officers, including the investigating officer Captain Kubai. I was informed that my arrest followed a warrant of arrest being authorized by a magistrate. Paragraph 22. Captain Kubai will no doubt confirm that I cooperated fully with the police upon my arrest, being detained in a room in my home whilst, ostensibly, the police undertook a thorough search of my residence over several hours. 23. As a result of the search and seizure, the officer seized a quantity of state-issued ammunition from a safe on the premises. The ammunition was lawfully issued to me in my capacity as the Deputy Chief of the EMPD. I am confident that the administrative exercise in confirming such fact with the EMPD systems will confirm this. I mentioned that shortly after my suspension in November last year, EMPD officers attended at my residence and had lifted my state-issued firearm and other equipment issued to me by the department. Upon informing the officers of the ammunition in the safe, I was informed that the attending officers were not from the Armory Department and were simply carrying out the instructions of their superiors to uplift the said firearm and equipment. I was informed that an officer from the Armory would attend at my residence at a later stage to uplift the ammunition. I point out that in these circumstances, it would have been unwise for me to transport the ammunition to the Armory to hand it in. I submit that I have acted reasonably and prudently in the circumstances, regard being had also to the fact that for the last few months I have been challenging the lawfulness of my suspension. 24. Upon conclusion of the search and seizure process, I was taken to Midrand Police Station at around 10 o'clock in the morning, where I was charged and processed. During this time, the police disclosed to me, briefly, the basis of the allegations against me, namely that I was complicit in receiving a bribe to the tune of 200,000 rands sometime in 2019 from Kagiso Lerutla. Lerutla, who was the city manager of Ekurhuleni at the time, was facing a charge relating to a speeding offence. Allegedly on my instruction, Tabang Tsotsetsi, who was a security officer at the time, appeared in court on Lerutla's behalf, and following this arrangement, Tsotsetsi and I received a bribe in the amount of 400,000 rand, which monies we then shared equally. In other words, it was the police officer's contention that this arrangement, which had resulted in a payment of 1,000 rand fine, involved a quid pro quo, a bribe of 400,000 rands. 25. Following my arrest on Saturday, 18 April 2026, Tian Peters of my attorneys of record attended at Midrand Police Station and consulted with me. We then discussed the matter telephonically with Captain Kubai, who confirmed the said facts presented to me. Other than confirming this, Captain Kubai was not willing to provide any other information relating to the matter. However, he did convey that I had already been charged and processed and would be brought to this honourable court on Monday, 20th April 2026, where I could bring an application for my release on bail. Given the paucity of information furnished to me and my legal representatives regarding this matter, I have been unable to determine with any certainty the exact schedule that bail application would fall under in terms of our criminal law, and as such, they have been advised to proceed on the basis of the matter falling under the ambit of Schedule 5 bail application, given the quantum that is purportedly involved. I believe it prudent to also mention that during the discussion between Peters and Captain Dubai, it was disclosed that the police held a preliminary view that the state would not oppose bail inter alia on the basis of me being a public figure and me having been arrested in my place of residence. I accepted this was the prima facie view of the investigating officer, which he did point out at the time may not be the view taken by the prosecutor seized with the matter. 26. I emphatically deny any involvement in any charges being preferred and specifically deny having committed or having any prior knowledge or involvement in the commission of the offence in question. I expect that once I obtain docket disclosure, in particular the various statements by witnesses and the like, I will be able to fully disclose my defence and rebuttal to any adverse allegations. I have no doubt that I will be completely exonerated in any trial. I wish to state that given the negative publicity that I have attracted in the media, I am of the considered view that a fully ventilated trial is the best vehicle to completely exonerate me of the charges and moreover completely clear my name in the public forum. 27. Though it is complete speculation on my part at this stage, I believe that my arrest has been orchestrated by individuals for ulterior and nefarious political motives.
People, please, I want all the cell phones to be off. This is very inconvenient. May I proceed?
Thank you, Bishop. It is no secret that I have made known my aspirations of applying for the position of Chief of Police, which office will become vacant at the end of the year. Of course, my arrest and prosecution negatively impacts my eligibility for the role, if not, in fact, bars me completely from being considered for it. 28. In similar vein, I reiterate the inherent implausibility of the narrative of the state's case. Respectfully, it is notionally absurd to the person, the second applicant, would pay a bribe of 400,000 rands to free him up to attend an important job interview and avoid a court appearance and or, in brackets, the state allegations are vague in regard to the precise quid pro quo to the bribe, to avoid the consequences of a speeding-related offence. Respectfully, common sense and experience suggest that the former could simply have been remedied by way of the presiding officer being informed of the importance of attending the job interview and prior arrangements being made for an appearance at an appropriate time of day on the date of the court appearance. In my experience, this occurs every day in our courts, with presiding officers accommodating accused persons in this regard. Alternatively, an accused person could choose, admittedly also dishonest, the quick and easy solution of obtaining a medical certificate, which I recently read practitioners often sell to truants at the princely sum of £100 or so. Furthermore, and directed at the state's contention that the bribe was paid for the avoidance of the consequences of the speeding-related bribe, as a seasoned EMPD officer, which sentiment I respectfully submit the presiding officer will no doubt share, such offences attract fines of a few thousand rands, hardly anything remotely to the tune of 400,000 rands. 29. Adding to this implausibility in the state case, I point to the extraordinary blatantness of the charges being preferred herein. Remarkably, the state admits, in brackets, this also appears from the police case number 345-03-2026, end of brackets, that whilst it contends that the offence was committed on the 13th of March 2019, the charges were only laid some 7 years later, in March 2026. Paragraph 30. I submit that clearly the state case against me is extremely weak, even without being further subjected to the rigors of the examination in the trial. I dare say, regard being had to the inherent implausibility of the state case and the timing thereof, that such case is actually non-existent. Paragraph 31. I am innocent of the said charges and intend pleading not guilty at my trial. Indeed, I expect with a great degree of certainty that once the political influence that has been brought to bear on the matter no longer prevail, the state will not persist with such charges, though as stated before, I welcome and prefer being exonerated in a properly and fully ventilated trial. Flight risk. Paragraph 32. I believe it will be common cause, inter alia, that I was arrested in my place of residence, which is well known to the police, given the nature and position of my employment. I'm a public figure having appeared recently in the Madlanga Commission of Inquiry. My personal circumstances, etc., have become well known to all and sundry. 33. My name and face are known to many, if not most people in our country, and indeed to many people in the world, given the widespread media attention that this matter and the Madlanga Commission of Inquiry has attracted. In the circumstances, I submit that I am clearly not a flight risk. I am advised that this is the principal consideration in the granting of bail. At my first appearance, the State's initial reason for seeking a postponement was to verify my co-applicant's address. I do not believe the State views me as a flight risk. Paragraph 34. Candidly, I am at a loss on what grounds the State opposed my release and bail. At my first appearance, this court will confirm that no grounds were stated. I am advised by my legal representatives that possibly the State may perceive my release to be a threat to the investigation and may result in interference with State witnesses. Unequivocally, I am emphatic that there is no basis for such fear. I am suspended from my admittedly influential position as the Deputy Chief of the EMPD. I therefore have little, if any, influence over the investigation and any potential witnesses. In fact, I do not know who the witnesses are. It is also important to point out that this matter is being investigated by a specialized task team on the one hand and prosecuted by specialist prosecutors from outside the province on the other. Clearly, the, albeit unthinkable threat of interference is unlikely, if not mostly improbable, in this matter. Paragraph 35. More pertinently, any possible fears on the part of the State, and I must emphasize that these fears are ill-founded, in regard to interference with State witnesses, can satisfactorily be assuaged with suitable and indeed stringent bail conditions being imposed on my release. 36. I have no desire to flee from the police nor to avoid the due and proper administration of justice. I have respect for and full confidence in the South African system of justice and law courts and intend standing my trial hearing. 37. I have no desire to even contact any State witnesses nor potential State witnesses. Indeed, I do not even know who such State witnesses are. Again, I submit that bail conditions prohibiting communication with any possible witnesses can clearly and effectively be enforced. 38. I have no desire to flee from the police nor to evade my trial hearing and do not wish to avoid the due and proper administration of justice. I will not commit any offences. I submit that there is no likelihood of me endangering the safety of the public or any person or indeed the public interest. I will certainly not undermine the justice system, and I will stand my trial and abide by any further conditions the court may seek to impose. 39. I humbly submit that the interests of justice do not require that I remain in custody pending the finalisation of my trial, which I am informed may take many months to finalise. I undertake to attend court religiously and faithfully each and every occasion to which this matter is postponed until its conclusion. I further undertake to comply fully with each and every bail condition that the court may seek to impose, should it see fit to grant me bail. 40. As regards the amount of bail, I am able to raise an amount of approximately 10,000 rands, but of course will be able to raise a further amount through loans from friends and family, which loans I will have to repay. With respect, I do not believe that it is the quantum of bail that secures my return to court and compliance with any bail conditions, rather than the fact that I am anxious to assert and prove my innocence of all wrongdoing in this matter, and moreover my full confidence in our justice system. In support of the allegations herein contained, I next hereby mark JM1, the confirmatory affidavit by my attorney Tian Peters of my attorneys of record. Wherefore I pray that may please the above honourable court to grant me bail as requested, coupled if need be with any bail conditions, including if need be in the most stringent of conditions until the matter is finalised. Your Worship, this was then duly signed by the applicant and commissioned before Commissioner of Oaths. Your Worship, JM1 is the confirmatory affidavit by Mr. Tian Peters. It reads as follows. I, the undersigned, Tian Peters, do hereby make oath and state that 1. I'm an adult male attorney duly admitted and the facts herein contained are, unless otherwise stated or unless the context otherwise indicates, in my personal knowledge and belief, both true and correct. 2. I confirm that I am employed as an associate at the firm Julius Associates Incorporated, the attorneys of record for the first applicant, Julius Mkhwanazi. I'm dealing with the first applicant's matter at our firm. Paragraph 3. I confirm that I have read the first applicant's affidavit in support of the application for bail and confirm the contents and correctness thereof insofar as same relate to me. Similarly, Your Worship, this was duly signed by the deponent, Mr. Tian Peters, and commissioned properly before a duly appointed Commissioner of Oaths. If Your Worship is satisfied of the confirmation by the applicant of the contents hereof, I will then leave to hand this up and the court to accept it as Exhibit A, Your Worship.
Thank you. Will you stand up, Mr. Mkhwanazi? You confirm the contents of this statement has been correct?
Yes, Your Worship.
Thank you. It shall be Exhibit A. Mr. Wilkins, any more evidence for the applicant?
None, Your Worship. That concludes the case on behalf of the first applicant. At this stage. Thank you.
Mr. Harris.
Let's go to Commissioner.
Thank you, Your Worship. We too, on behalf of the accused, have prepared an affidavit for bail. Where's my copy? I beg leave to hand up the original for Your Worship to follow. There will also be a confirmatory affidavit from his wife. It has the heading of this matter, and it states, I, the undersigned, Kagiso Michael Lerutla, do hereby declare under oath as follows.
Again, I don't know if my elephant is not
Oh.
to follow.
Copy. And a copy for me.
It's the confirmatory, and that's a copy for you.
Sorry, Your Worship. I'm the applicant in this matter. The facts contained herein are within my personal knowledge and belief, and are both true and correct, save where the context indicates otherwise. Under the heading Personal Details, I'm a South African citizen who was born and bred in Jane First, Limpopo Province. I was born on 15 March 1996, and that makes me 40 years old. I reside at number 6, Teak Street, Serengeti Estate, Ekurhuleni, Kempton Park, Gauteng Province. I'm a tenant at that property. See copy of the lease agreement and my identity document marked Annexes A and B. If I could just go to A and B. I don't intend reading out the whole lease agreement, but there's a copy.
This agreement is the new one. Let's agree.
Sorry, Your Worship, I just can't find Annex A.
This one.
I'll return.
Annex A is the ID. It's my original.
Oh, I see. Annex A is with your original, Your Worship.
Yeah, no,
It's not in my copy.
Yeah, it is the copy
Sorry.
of the ID.
Sorry for that interruption. And then Annex B, you'll see there's a landlord whose identity is not particularly relevant, but the tenant is Kagiso Michael Lerutla, and the address is 6 Teak Close, Witfontein Extension 27. That's the property description of 6 Teak Street, Serengeti, Ekurhuleni, Kempton Park. As Your Worship knows, the street addresses compared to a property description are not always the same. But it's 6 Teak Street, Serengeti. Then paragraph 3.1. I do have 2 valid passports, one being an official passport. The official passport was issued to me because of my official position as city manager of Ekurhuleni. I am prepared to surrender both passports in case that is required. I'm married to Ntabiseng Lerutla. My wife is unemployed, and we have 2 daughters, and their ages are 6 years and 8 years respectively. They're both at school. These children live with us at our primary residence mentioned in paragraph 3 above. My family is therefore entirely dependent on me for survival, as I'm the sole breadwinner. Employment status. I'm currently employed as city manager of Ekurhuleni municipality as from 1 November 2025. I earned 220,000 Rand per month. Prior thereto, I was a Group Chief Financial Officer at Ekurhuleni Municipality from 1st of June 2019 until the end of May 2024. I was reappointed to the same position on 1 August 2024 until end October 2025. Paragraph 3.4. I'm a qualified chartered accountant and I hold the following qualifications: BComp degree, University of Limpopo; BCom Accounting Honours, University of Johannesburg; MBA, Regenesis Business School, and I'm currently expecting the results for the Masters of Philosophy in Accounting from UNISA. I've been advised by my legal team that the offences with which I have been charged fall under Schedule 5, and therefore the onus is on me to demonstrate to this Honourable Court that the interests of justice permit my release on bail. Next paragraph. I've been further advised that the contents of this affidavit may be used by the state in a subsequent or the subsequent criminal trial. Rootedness in South Africa. I'm deeply rooted in the Republic of South Africa because all my family members live in the Republic of South Africa. I normally travel between Gauteng and Limpopo provinces to visit my family members. I have travelled overseas for both holidays and work purposes in the past. However, I have no intentions to emigrate from the Republic. Circumstances leading to my arrest: I was arrested at OR Tambo yesterday. That's the airport, 19 April 2026. In the presence of my friends, family, after returning from Cape Town, I fully cooperated with the police during my arrest. The police advised me that I will be facing the charges of fraud, corruption, and defeating the ends of justice. I intend to plead not guilty to these charges. However, I still need to consult with my legal team properly after the docket has been disclosed. In the absence of the docket disclosure, I cannot therefore comment on the merits of the state's case at this point. I'll argue on that later, as my learned friend has done. Assets. I have the following assets. I have one immovable property situated at 24 Milderbosch Estate, Brentwood Park. The latter property is rented out to tenants. This property is bonded with ABSA, and I'm paying a bond of about 19,000 Rand per month. I own home furniture items and personal possessions worth about 400,000. I also own one motor vehicle, a BMW X5, whose registration number I can't remember at this stage. Pending cases. I've been advised by my legal team that I'm required by law to correctly and truthfully disclose my previous convictions and the pending cases, and in the event that I provide any false information, I may be punished by a court of law. I do not have any, and/or I am not aware of any pending criminal investigations or cases and/or warrants of arrest against me. Previous convictions: I do not have any previous convictions in my name. Protection orders and/or parole. There are no protection or harassment orders issued against me either under the Domestic Violence Act of 1998 and/or Harassment Act of 1997, and I am not under parole. Submissions regarding factors to be considered when deciding whether to grant bail, and these, Your Worship, as you know, are the key factors. Section 64A, endangering public safety or anyone. I submit that I've never been involved in harassing or intimidating any member of the public or witness in the past concerning this matter, and I have no reason to do so. Accordingly, no one will be in danger if I am released on bail. No evidence exists for this court to reasonably suspect that any member of the public will be in danger if I am released on bail. Then under Section 64B, likelihood to evade trial, I'm deeply rooted in the Republic, and I have a stable and gainful employment as well as a stable family. I do not intend to emigrate from the Republic as already stated above. Section 64C, interference with state witnesses. I do not know who the exact witnesses are in this matter, and I have no reason to interfere with them. I am fully aware that it will not be in my interest to interfere with any of the witnesses in this matter, as that would place my bail at risk. Section 694D, jeopardy to functioning of criminal justice or bail system. I do not have any knowledge whether the police investigations are complete or not at this stage. I also do not have any knowledge as to how the police will pursue further investigation, if any, at this point. I provided full and correct personal details to the police for this matter. Accordingly, it's impossible that I can interfere with the police investigations in any manner and or jeopardize the criminal justice system. Exceptional circumstances, section 694E, presence or absence which may lead to undermining public order or peace. I submit that no public order or peace will be disturbed by my release on bail. No evidence exists and or has been brought to my attention to suggest to the contrary. Provisions of section 69, the interest of justice in relation to the right to be released on bail. I submit with respect, if this Honourable Court does not grant me bail, my family and I would suffer grave and irreparable prejudice. The prejudice will be in the form of lack of support to my family, as they would be deprived of the love, emotional and financial support from me. I was made to understand by the arresting officers that I would be facing many grave charges in this matter. This means that I would really need to conduct regular and comprehensive consultations with my legal team, and also gather a lot of exculpatory evidence material for them to prepare, if I'm kept in custody but not be able to effectively prepare for my trial. I'm advised that the wheels of the criminal justice system in the Republic grind very slowly. I'm advised further by my legal team that there are huge backlogs in courts, and if I'm not released on bail, it may take more than 9 months to a year before the trial is concluded in this matter. In view of the aforementioned factors, I respectfully submit that I am sufficiently rooted in the Republic. I have significant assets and I have no history of criminality, and I'm therefore a suitable candidate to be released on bail. My constitutional right to presumption of innocence still operates, despite the alleged serious charges that I'm facing. It is therefore impossible that I would leave this country as a direct consequence of this case. There are no reasonable grounds to believe that I'm a flight risk. I'm willing to abide by any reasonable bail conditions, including reporting to the police every day. I can raise up to 20,000 Rand for bail. And Your Worship, if I could hand up the original of a confirmatory affidavit by my wife. It has the heading of this matter. I, the undersigned, Tabi Singh Reni Lerutla, do hereby declare under oath as follows. I'm the wife of the accused person, Kagiso Michael Lerutla, my husband, the applicant. See the attached marriage certificate marked Annex A. I'm sure you have it, Your Worship.
Yes, it is attached to the affidavit.
Very well. The facts contained herein are within my personal knowledge and belief and are both true and correct, save where the context indicates otherwise. This affidavit serves to confirm that I reside with my husband and our 2 daughters at number 6 Teak Street, Serengeti Estate, Ekurhuleni, Kempton Park, Gauteng Province. We are tenants at that property. See copy of the lease agreement and my identity document marked Annexes B, respectively. I take it that they are very worshipful. It's the same lease agreement. We have also another immovable property situated at number 24 Mulder Bosch Estate, Brentwood Park. The latter property is rented out to tenants. This property is bonded with ABSA, and I am paying a bond of about 19,000 Rand per month. That is the confirmatory affidavit, Your Worship. Of course, in due course, I will address you on the various factors, but that is the affidavit and the evidence for the time being.
Thank you. Would you stand up, Mr. Lerutla? Do you confirm the contents of your affidavit as being correct? Do you confirm the contents of this affidavit signed by you as being correct?
Yes, I confirm.
Thank you. This affidavit by Mr. Leruti shall be Exhibit B, and the confirmatory affidavit shall be attached thereto as part of it.
This is the court order.
Thank you. Any more evidence for the second applicant?
No, Your Worship.
Thank you.
Then, Your Worship. Your Worship, in opening our case, I would ask the court to indulge us to consult with the existing team, because there are new things that were not in our affidavit that are prepared, to see how we can include them in the affidavit.
How much time do you need?
An hour, Your Worship. I can see there's a lot of things.
How?
Hour is a maximum. Then if we did not take that hour, we'll indicate the court.
Well, I'm not preempting anything,
Yes,
but when the person is arrested, immediately there and then, the arresting officer or the state must already start considering the issue of bail and the grounds of opposition, if any. When I look at these affidavits, what is being said there are commonplace things which often come for consideration during bail application. I don't see anything which is peculiar and that could possibly come as a surprise. Like where the person is staying, does the person have previous convictions, any pending cases, passports, travel outside, such issues. But be that as it may, I'll grant you that indulgence, but I find it very disconcerting.
Maybe it's going to be less. I was missing the hour as a maximum, but it will be better less than that. I will indicate to the court once we finish meeting.
Any comment from you, Mr. Wilkins?
So I have to echo Your Worship's sentiments with, I have nothing further to say.
Similarly, Your Worship, cannot do any better than the court have done.
Thank you. The court will take a break, and then once the state is ready, we will reconvene and then proceed further. Court adjourns.
Kansas, are you ready to argue today? Eh? Yeah. I mean, I can see you have brought your. As a purpose is Your Worship, the state appreciates what the court has done to give us that enlargement. And we didn't take that hour, as I promised, Worship. Hence we are here now.
Thank you.
Thank you, Worship. Worship, I'm ready to open the state case, and Worship, we have also prepared an affidavit from the investigating officer, and Worship, it has 2 annexures, that affidavit. May I hand the court copy? Yes. Applicant 1 and 2. May I proceed to receive and read for the record?
You may proceed. The accused may be seated in the meantime.
Thank you, sir. Thank you, Worship. Your Worship, the affidavit reads as follows. It is an affidavit in opposition of bail. I, Slindile Sbahle Mdinane, hereby make an oath and state as follows. I am an African female member of the South African Police Services, holding a rank of a sergeant, and I am serving at SAPS head office, currently attached at the Madlanga Task Team. This team is a multidisciplinary component where you find different units grouped together. For example, the detectives, ballistics, local representative officers, amongst others. Your Worship, I'm going to leave the address part as a court visit, so without leave your worship. I am a detective in the South African Police Service with 17 years and 3 months of service experience in the SAPS. All these years, one has been working as an investigator. I have extensive experience in investigation of murder, possession of unaccessed firearm, and possession of ammunition without a permit, Act 60 of 2000 of the Firearm Control Act, corruption and fraud, that is high-profile cases. Paragraph 3. The applicants are facing serious charges which have big negative impact in the criminal justice system of our country. These charges are ranging from 1, defrauding the criminal justice system, where the right accused was deliberately impersonated. 2, defeating or obstructing the administration of justice. And corruption, where applicant number 2, who was looking for a promotion to be a chief financial officer, paid a bribe to his colleagues to save him from having a criminal record in his profile by hiring someone for payment of 400,000 to impersonate him. This was calculated in order, after a conviction, for his fingerprints not to be read from the fingerprints in the criminal record. In relation to the third offense, they are charged with, in relation to the third offense they are charged with is a payment of this 400,000 by applicant number 2, paid in gratitude to the third person who agreed to impersonate him, to share it with applicant number 1. Evidence will show that applicant number 1 received an equal share of the amount. I am advised that this conduct of paying 400,000 rands constitutes Schedule 5 offence in terms of the Criminal Procedure Act 51 of 1977 as amended. The charges we are investigating are related to offences that had an impact on rendering justice to the public, to the public of this country. I noticed that the fourth charge of unlawful possession of firearm now is just spilled on over the next page. I noticed that now. Upon arrest of applicant 1, we found 153 9mm live rounds and R5 assault rifles, which is 15 rounds. His explanation was that this ammunition belongs to his employer, of which is Ekurhuleni municipality. Subsequent investigation has revealed that applicant 1 is on suspension. He was ordered to hand in all the municipal property in his possession. A copy of his suspension letter is attached as Annexure B. May we look at it, Worship, now before I move further? Is at the last exhibit of the Annexure B. Worship, I'm not going to read the whole letter, but I will just read what is important. That
the one dated 12 February 2022.
Yes, Worship. Is the extension of suspension. It says, Your Worship, Dear Mr. Mkhwanazi, the City of Ekurhuleni has taken a decision after careful consideration to extend your suspension. Therefore, your suspension is extended from 14 February 2026 to 13 May 2026. Therefore, Worship, he's still on suspension. We can go back, Worship, to paragraph 4. The case against the applicants, is as follows. The background of all that led to the arrest of the two applicants started when, in July 2025, Lieutenant General Julius Mkhwanazi called a press conference where he painted events that showed an assault on the criminal justice by the people who were entrusted to look after it. 4.2. The state president responded to this allegation by forming a commission of inquiry to investigate them. This commission is famously known as Madlanga Commission. This commission handed recommendations with names to the president, who were implicated by evidence in this commission as having played roles undermining criminal justice system by conducting themselves in a way that undermined the administration of justice to hold on to power and lined their pockets by misusing public funds. 4.3. In 2019, the applicants were both the employees of Ekurhuleni Metropolitan Municipality. On the 9th of March in 2019, applicant 2 was arrested for speeding and was detained at Boksburg North Police Station. Applicant 1 received a call while he was in company of his driver. And after the call, he informed the driver that applicant 2 was in custody. Applicant 2 was released on police bail in the amount of 1,000 rands and was warned to appear in court for first appearance on the 11th of March. 4.4. Applicant 1 suggested to his driver that applicant 2 needed his, that is applicant number 1, needed his assistance since he was going to undergo interviews for the chief financial officer position in the municipality. It was when applicant 1 instructed his driver to go to Boksburg Magistrate Court to appear on behalf of applicant 2 to save his promising career. The driver obliged, since there was promise of monetary incentive. When the name of the applicant was called in court, the driver of applicant 1 responded and entered the dock. The driver was so relieved when he was not given custodial sentence, but a diversion program where he was supposed to attend classes thereafter. He was ordered by the social worker to pay an amount of 800 rands for the program registration, and he paid it from his pocket. The investigation revealed that he never attended the program further from that day. 4.7. Applicant 2 paid the driver of applicant number 1 of about 400,000 in installment, which he shared equally with applicant number 1. From this incident, applicant number 1 used him more often to assist other department officials who had the same problems. 4.8. This is an assault to the criminal justice system by the persons who were supposed to protect it. This amounts to the breach of trust. Paragraph B. Consideration in terms of section 60, subsection 4, paragraph A to E of the Criminal Procedure Act 51 of 1977. That is, Your Worship, the paragraph 5. I'm starting with the paragraph 5. I am opposing to the release of the applicants on bail based on the following reasons. 5.1. I fear that they will interfere with the investigations. 5.2. Further, that there is a strong likelihood that they will interfere with the witnesses. Paragraph 6. Okay. Why I say there is likelihood that they will interfere with our investigation. 6.1. This incident occurred in March 2019 where the applicant 1 was occupying the position of a superintendent, and applicant 2 was gunning for the position of a CFO in the municipality. It is common knowledge that applicant 2, the applicant, I think, is an applicant who got the post for which he was interviewed. He was appointed as a CFO in 2019 after that interview. Both applicants, with the help of other people unknown to the police yet, managed to totally kill investigations related to this matter ever since, until Madlanga Commission Task Team was formed. That means without this team, the case, which has embarrassing effect to the criminal justice system, would have permanently buried. I shudder to think what would have happened if the prison officer had given the driver direct imprisonment. Wrong person would have served the sentence for the crime he did not commit, making mockery of the court and the entire criminal justice system. Paragraph 7. Why I say there's a likelihood that they will interfere with our witnesses. 7.1. Both applicants know their state witnesses very well, and those witnesses are gullible and vulnerable since they were serving under them. They owe their everyday work conditions to the applicants. Further on applicant 1, that is now we are on 7.2, Your Worship, there is evidence that persons who were close to the applicant number 1 died in the hail of bullets. It also revealed that all those witnesses were about to blow whistles on corruption and murder in the municipality. Examples of those are: bullet point 1. It is public knowledge that the famous deceased witness D told the country that applicant 1 was called to the murder scene at 2 o'clock in the morning, 11 hours of the morning, where he ordered the disposal of the deceased body into the dam. In his statement, he gave to the police, witness D listed several persons who were present when applicant 1 arrived at the scene. Your Worship, this statement is attached as Annexure A. I want to ask the court that I will read it after I have read the affidavit, because it is longer. This included the deceased potential witness who called him to the scene. That is Yako Hanekom, who is under Boksburg CAS 2163 of 2013. That is the docket of that witness, the dead witness. Another person who was present was one Willem Pretorius, under Brakpen 139 2025, attempted murder, and Sergeant Khoza of Tsakane CAS 27510 of 2025, that is murder in that one. One thing is common about them is that they all died from bullet wounds. It would be reckless of me to ignore these hard facts, especially when they are dealing, when they are already in the public domain. I feel duty bound as an officer responsible for the public order to bring this to this court attention. These events inspire fear in the investigations and the safety of the witnesses. Now, further on applicant 2, evidence, that is now 7.4, Your Worship, evidence revealed that on the 14th of May 2021, at about after 12 midnight, 10 past 12 midnight, applicant 2 was driving a black Mercedes G-Wagon with registration number JH60JBGP along N12 eastbound when he got involved in a collision with a Hyundai whose driver died on the scene. The scene was attended by 2 EMPD officers who allegedly arranged for applicant 2 to be transferred to hospital for medical attention, as he was allegedly seriously injured. However, the applicant was attended to at the hospital and discharged the same day without being admitted. Case of culpable homicide was registered as per Bedford View, CAS 106, 05 of 2021. Closed as withdrawn on the 28th of August 2023, but it is mysteriously missing from the SAPS storeroom where it is supposed to be kept. 7.5. The investigation in the culpable homicide docket placed us in a position to reconstruct the missing docket, and the reconstruction is at an advanced stage, including the investigation regarding such loss of the docket. 7.6. In the reconstruction of this docket, investigation revealed that immediately at the crime scene, the tow truck driver was offered an amount of 10,000 rand by the applicant number 2 to remove the body from the scene before the role players arrived at the crime scene. There is a statement to this effect. Your Worship, it is signed on this 23rd day of April 2026 here in Boksburg and is commissioned yesterday. May I read now the Annex A?
May proceed.
Thank you, Worship. Worship, it is under Duduza CAS 91 of April 2022 and it is a meta docket. The witness is Marius van der Merwe, state under oath in English. I am an adult May, self-employed as a consult. Worship, I'm going to live there where he resides. On Thursday, the 14th of April 2022, at about 9 o'clock in the evening, I was contacted by Cobus, who is the director of Coast Guard Security situated at Springs. He was informing me about the warehouse robbery that took place at Boksburg area, saying that he had location about the suspects. He also asked me if I was available for backup. I told him that he must send me a pin drop for location. Paragraph 2. Copper sent me a pin drop on WhatsApp. It was for Salis village. I arrived at the location at about 20 minutes later. I found Yako Hanekom and Coppas at the location. Yako is an informer. That I was driving a company vehicle with a number HW02WFGP, which is a marked Guardian Security Ford Ranger and black in color. Yako Hanekom's contact number, I'm not going to read it for the family members. And he was driving a red or maroon Renault Kwid HL06DD EGP. I cannot recall what Cobus was driving. Paragraph 3. I got out of the car and greeted them, and 3 unmarked EMPD vehicles arrived, and they were Golf 7 GTIs. Inside 2 of the EMPD vehicles, they were driving by Kesia Listols, and other vehicle was driven by Aiden Mackenzie. The third vehicle was driven by a colored male. Kesia's got a number, and Mackenzie, I'm not going to read them, and they both employed by EMPD as police officers. They all got out of the vehicle and greeted us. Zander Fritz also arrived with 2 African males that were in full uniform in a marked SAPS BMW, marked black band with its call sign BP32 Zander was wearing a police trouser, police boots, and a black or blue T-shirt with black bulletproof on top. VM Pretorius, that is now paragraph 4, Your Worship, VM Pretorius and Constable Yuan Mary Extian arrived shortly after that. They both arrived in one vehicle, and I cannot recall if it was a Hilux or a Ford Ranger. VM's number, I'm not going to read it, Your Worship, with the permission, and he introduced himself as a SAPS employee, but to my knowledge, he's not employed. Yuan Mary Extian and is stationed at North Rand Flying Squad in Benoni. They also came and joined us. They both explained that they were waiting for 2 extra members. Those members that Viendra was waiting for came in one vehicle. I cannot be able to identify them. Also, Etienne van der Walt from Titan Security arrived with a white female unknown to me, and they were driving a Kia Sportage, silver in color, and did not obtain registration numbers of the said vehicle. We were briefed by coppers from Coast Guard Security that the vehicle that was identified as a business robber was parked at a certain yard at Salis village. He further informed us that there were a number of heavily armed suspects at the address. Shortly after that, we took our bulletproofs on. We drove in a convoy to the address that was identified by Yago to us. It turned out that we started at the wrong address, and we thereafter proceeded to another address just down the road and stopped at that residence. Paragraph 7. All members got out of their vehicle, and I was the last one to get out of the vehicle. A large group of the members proceeded to the main house, and they were led by Jacob and Viandre. I followed Constable Extin to the outside rooms of the property. When we got to the door of the outside dwelling, we were met by Mackenzie, and they introduced themselves as the law enforcers to the occupant. There was colored male and colored female and a toddler, and they were in one room. Yuan Marie and Mackenzie went inside to search the room, and they inquired about the owner of the truck that was parked in the yard. And a response from the colored male that the truck belonged to the owner of the property, but he did not know if he was home or not. We were notified by one of the members that they had found the owner, and he was inside the main house. We proceeded to the main house through the back door that was leading to the kitchen. Before we entered the house, I saw the 4-ton truck that was parked inside the yard, but it was not visible from the street. I did not manage to get the registration of the truck because one of the metro officers had already removed the registration plate, and they were seen inside the house. Paragraph 8. I asked the coppers if he could confirm if it was that truck. He said yes. I proceeded through the kitchen and realized that there was commotion in that passage. I then saw an African male that was being grabbed by a waist of his pants by 2 SAPS members that were wearing uniform, and they said here was the suspect. Viandre told the suspect that he should know as to why we were there. The suspect had confused look in his face. Viandre asked him to show us the stock hidden. That African male agreed that he was going to take us where the stock was. The suspect further explained that there was money inside the house and said we can talk. The suspect was then pushed to the bedroom. Paragraph 9. He was pushed by the same African SAPS members that were wearing uniform, and he landed on top of the bed facing up. Viandra was sitting on top of him, pressing him down, and the 2 SAPS were restraining him from the head and hands and the other one was assisting him on the waist down in order for him not to stand up. I stood on the doorway, and told Vianda that he must remember that we must find the stock, and Vianda said I should not worry because the suspect was going to talk. Vianda asked the suspect about the money, and the suspect was crying and he couldn't talk clearly. Paragraph 10. I left the room where the suspect was and went to join Etienne, Kobas, Yako and Kesia in the main bedroom. I conducted search and recovered live ammunition and a leather firearm holster. I told the member to keep an eye to those exhibits and went to another room. That room was full of garden tools and other things. We found Mackenzie searching the cupboard that was having mags and tires, and he took them. We were all searching. At the kitchen, I saw Zander, Johan Marie, and an unknown SAPS member, and they were searching. Paragraph 11. I went outside and looked at the truck. One member took out a disc from the truck, and we were waiting for those who were still searching. I went back and told Vianda that he should not forget that we still need to recover the stock. I then realized that the suspect was crying, and whenever he tried to talk, he was spitting saliva or liquid from his mouth, yellowish in color. He was indicating that he was going to show us where the stock was. I then went out of the room and met one member carrying the bottles of water in his hands, and I realized that something was not right. Paragraph 12. After about plus minus 30 minutes, I went back to the room. I sat on top of the bed, which was wet at that stage. I asked the suspect to show us as to where was the stock. I even begged him to talk in order for us to help him. He tried to respond, but I could see that it was strenuous to him. He spitted some liquid on my eye. I then went out of the room to get water from the tap in order to clean my eye. As I was standing inside the kitchen, I saw Kesia wearing the surgical gloves, and I asked as to what was happening, and she did not respond. Paragraph 13, I left the house and went outside, find other members sitting on the grass and others standing. The two SAPS members in uniform came out of the house with a small safe or container. They went past us and never said anything. A few minutes later, Vianda came out and told us that the suspect was not going to talk anymore. And Vianda further said how we were going to contain all that. Johan and Zander said that they were going to fetch the firearm because they were planning to shoot the suspect who was deceased. And they were going to plant him with a firearm in order to make it look like a self-defense. They were driving in that marked BMW. After that, Ukobas left and other MP and other members left also. I was only left with Kesia, Mackenzie, Viandre, Yako, Etienne, and one EMPD member. As we were standing there, Viandre told us that if we talk, he was going to kill that person himself. Viandre, as I said, that he was going to call General Khan to assist with the deceased. He then changed and said he was going to call Colonel Dawood, and he was asking if he should call him. Paragraph 14. Yeah, of course, they said that they should call their chief, whom they call Julius. And he turned around and said he was going to call Mkhwanazi, whom he said he was his chief. He then used his phone to call him. Julius Mkhwanazi arrived a few minutes later, and he introduced himself as Superintendent Julius Mkhwanazi to myself and Etienne. Viandre then spoke to Mkhwanazi and said, "Chief, It's that time again. Close quote. Then they discuss the manner in which the body can be disposed of. And it said that I should follow them. I walked to my buggy and the EMPD member was following me. Viandre instructed me that my buggy will be loaded with the body of the deceased. Therefore, I should not worry because I will be covered. Paragraph 15. I then told him that it was my work buggy and it was marked. He said I should not worry because no one was going to pull it over. I noticed that 2 members were having guns in their hands. And Viandre said people will die for this. He told me that I should park the buggy next to the room where the deceased was. I did as I was instructed. They ripped the gate off and I drove in. I parked inside the yard and got out of the car. I went inside again. I then told Kesia, who was standing in the golf vehicle, that it was not right what was happening. And they were, it was not right that was happening there because that was not what we came for. Paragraph 16. I then saw Viandre and Jaco carrying the body from the house and threw it inside my buggy. And it was not covered, but the loosely fitted tracksuit-like jacket to the body. Mackenzie drove inside the yard and put the tires and mags inside the golf boot. Jaco loaded welding machine and a small generator and another item that I did not see what it was inside since his vehicle had not quit. And another item that I did not see what it was inside his vehicle Renault Crete. Julius was still inside the yard, supervising the whole issue of disposing the body. Paragraph 17. They closed the doors. Jaco and Etienne. I was instructed to follow them. They pulled out of the yard and I did as well. Julius also left and drove off. I was instructed to follow Mackenzie. It was Mackenzie, myself, Viandre, Kesia, Etienne, and Jaco. We proceeded out to Spring Road and to R23. They indicated left towards Heidelberg to R235. Jaco and Etienne turned left. Kesia pulled off as we were driving and turned back. We continued, myself, Viandre, and Mackenzie. On the way, I could not see Viandre anymore, who was following me. I continued with Mackenzie, who gave me the signal to follow him, as we drove slowly towards the Spa water dam. Paragraph 18. We drove slowly as he would stop and wait for me to follow. He then stopped and instructed me to throw the body inside the dam. I then stopped and opened the buggy and pulled the body down, holding it by the waist of the trouser and placed it next to the river bank, facing down. I then took the jacket and placed it on top of the body. The body never sustained any further injuries in my care. I did not place it inside the dam because I was hoping that someone will discover it. I then drove back and met with the whole team that was in the house, waiting by road next to the Carnival City. They asked me if I dropped the boat inside the water, and I said yes. But they wanted to be sure if I went inside the water. I told them that, no, I did not go inside the water. Christian then said it was done, and no one should talk about this on the phones. Viandre emphasized that if you talk about this, someone will die. Thereafter, I then drove back home, leaving everyone there. Paragraph 19. On Saturday, the 16th of April, at about 6 in the evening, I received a call from Joan Matri Extien using unknown number, and he said we should meet in a spot where there were no cameras. He said we should meet Rose Tuli. I then did go there after informing Cobus. It was myself, Zander Fritz, and Joe Marie Exten, Yako, and Viander Petorias. The meeting was chaired by Viandre, and they wanted to know if I was going to talk to someone about the death incident. I said, no, I will not talk. Then they said they did not trust Cobus, Yako, and myself. They instructed me to go and check if the body was not found. I did go and confirm to them that the body was no longer there. Paragraph 20. I'm giving this statement out of my free will, and no one forced me to give the statement. I swear that the above is true. So help me God. Your Worship, it is signed and commissioned.
This shall be Exhibit C.
For the court visitors. Your Worship, that concludes also the state case.
Thank you. Stand, please.
As is the court, Your Worship, we indicated in our original affidavit, if the state in their reply shares a new information, that we would request an opportunity to take instructions in that regard. In this respect, Your Worship, I think Your Worship will, upon a mere perusal of the charge sheet, see that the contents of the investigating officer's affidavit directly contradicts the charge sheet, and she makes allegations that is not contained in the charge sheet, Your Worship. We did not take instructions on it. We surprised by that, as well as the other annexes that is now attached. Under these circumstances, Your Worship, I would ask an opportunity to just consult with the first applicant and to take proper instructions as to how we should deal with this.
That was the main reason why I invited you specifically.
Yes. Thank you. Thank you.
Mr. Helens?
I need less of an opportunity, but seeing my learned friends taking an opportunity, I'll sail behind him.
You will then tell me when you are ready.
Thank you.
Thank you, Your Worship.
Court adjourned.
That
Worship, the court convenes after the adjournment.
Thank you.
Yes. Thank you, Worship. Your Worship, the court convenes after short adjournment that was asked by the defense to consult with the client, which was extended by us taking lunch. Now I think we are ready, Your Worship, to proceed further. I think the defense can confirm that.
Thank you.
They can print it out. So may I ask your Worship's indulgence that my learned colleague who has finalised his replying affidavit proceed and read out his affidavit. My affidavit should then be available at that later stage. So if your Worship would just grant us an shifting of the roles. Change of sequence.
No, I think I can deal with the sequence. It's not a problem.
Thank you, Worship.
Thank you, Your Worship. We have prepared a replying affidavit, which I beg leave to hand the original of up. And Your Worship will see how the time goes, but it may be that after I've done my affidavit, if the other affidavit is not yet here, I might also argue just to make sure that we use court time. But let's see how we go with the affidavit. I'm in your hands.
I'm going to suggest that we deal with your affidavit and then exercise a bit of patience to get the other affidavit.
Okay.
It will be proper to deal with arguments after hearing all.
That's perfectly normal and acceptable, of course.
Thank you. We then proceed.
Right, Your Worship. So it's in the nature of a reply, and I will advert Your Worship, if I may, to the areas that I'm dealing with as we go along so that it makes sense. It has the heading of the affidavit, I, the undersigned, Kagiso Michael Lerutla, do hereby declare under oath as follows. I'm the applicant in the matter. The facts contained herein are within my personal knowledge and belief and are both true and correct, save where the context indicates otherwise. And reply to the state affidavit. When I prepared my application to be released on bail, I was unaware of the basis upon which the state will oppose my bail, if at all they would do so, if at all they would so oppose my release on bail. I now wish to reply briefly to the averments contained therein. At paragraphs 3 and 4 of the state affidavit, now if one has regard to paragraphs 3 and 4 of the state affidavit, I'm not going to read it out, of course. Paragraph 3 describes the offences which we're going to be tried for, and paragraph 4 deals with the background to those offences. And this is the bail application, not the trial. So, add paragraph 3 and 4. I understand this to be the description of the state's case which they wish to present on my forthcoming trial. I've been advised that the bail application is not the occasion or situation in which to hold a trial within a trial. It should be a trial before a trial. Suffice to say, I categorically deny the description of the offence and deny that I'm guilty in any way whatsoever of the alleged crime. The probabilities scream out that no one will pay 400,000 rand to avoid appearing on a speeding case, let alone one where the facts clearly led to a deviation order or a diversion order. Then at paragraph 5 of the state affidavit, that, Your Worship, is a simple two-line, which says that the IO fears that will be interfere with the investigation, strong likelihood that they will interfere with the witnesses. Your Worship will note strong likelihood. There at paragraph 5, I deny that the fears raised in paragraph 5.1 and 5.2 have any basis in fact or are justified. I deny that I will interfere with the investigation or the witnesses. Then paragraph 6.2 That is the paragraph which says that, and I won't repeat it entirely, both the applicants, with the help of other people unknown to the police yet, managed to totally kill investigations related to this matter ever since, until the commission was formed. Well, what we say with regard to that is the contents of paragraph 6.2 are clearly speculative, and there is no justification in fact pleaded to underpin the allegation that I managed to kill any investigation. So it's an allegation, it's not a fact. Then at paragraph 7 of the state's affidavit, which is one which says that the applicants know state witnesses very well and they are gullible, etc. The statement is, I do not know who the state witnesses are. And in any event, there is no basis to suggest that I have a propensity to interfere with the investigation. Your Worship, we will later on refer to the law dealing with this extensively. Then the next is paragraph 7.4, because I'm only dealing on behalf of applicant number 2. So paragraph 7.4 is the evidence with regard to the road accident and accused number 2 being removed from the scene, and the allegation relating to the tow vehicle, just for everyone to picture what it's about. So at paragraph 7.4 of the state affidavit, the description of the alleged facts are completely at odds with the reality of that which occurred on that day. After the accident, the scene was first attended by members of the South African Police Services. After the SAPS members had arrived, my EMPD VIP protection officers arrived. I was indeed injured and bleeding from the face. Suspected head injuries are always serious. The EMPD officers asked SAPS if they can take me to hospital because SAPS members had not called an ambulance, which had arrived on the scene, which SAPS members agreed to. So had not called an ambulance, which had not arrived on the scene. At hospital, I was treated immediately, and I was discharged after a couple of hours. It is so that I was informed that the investigation into the culpable homicide had concluded with the decision not to prosecute me. I'm not aware as to how the SAPS filing system in its storeroom operates, and I had nothing to do with the missing docket. Nor does the state say that he did. I note that this investigation is by no means complete, and I am certain that if the investigation is objectively concluded, I will be found innocent of any wrongdoing. Then, with regard to paragraph 6, this is the alleged tow truck driver money. I made no offer whatsoever to any tow truck driver, as the tow truck driver either had not yet arrived by the time I was taken to the hospital, or if he had arrived, I did not see him, nor had any contact with him. My counsel will address all of the legal principles applicable to the above considerations in the address, Your Worship. So that is the short reply to the state's opposition in relation to accused number 2. And are you ready? The accused number 1 is ready.
Thank you. Mr. Leruta, do you confirm what is contained in this statement has been correct?
Your Worship, I confirm.
Thank you. Advocate Wilkins, are you ready?
Your Worship, yes, I have been provided with a copy of the affidavit. It has not yet been commissioned or signed by the deponent. May I?
This one which I'm having, I'm going to mark it Exhibit E, so as to maintain the proper sequence, and then
yes.
yours will eventually be D.
Okay.
Just take a 5 minutes break for you to get that one commissioned, then we proceed.
Your Worship, in order not to, and I know because of everything, but may I make another proposal, and that is that I read it out. Your Worship then confirm with the accused that he's happy, and then we will commission it, and then inform your worship when it's ready and hand it up to your worship.
It may look like a little technicality, but for
Yeah.
as long as it is not commissioned now, it is not evidence under oath.
As it please the court.
So for it to carry
Okay.
that weight,
Okay.
it must be commissioned first, and then once commissioned, be read into record.
As it please the court.
It may appear small.
No.
but that is the way it
Yes.
should be.
As it please the court,
Quite
your
correct.
worship. Thank you, your
So
worship.
just take a couple of minutes
Okay.
break, just to sort that out, and then we proceed.
Thank you, your worship. Thank you.
Trying to make him feel like a hero when
No,
I
he
say
is.
quite correct.
No, he is, but he is correct.
It is, but I want to make him look like a hero. I'm not criticizing you.
No, I know. I just take it. Get it in here. I don't know. Thank you, Your Worship. We're indebted to Your Worship. Your Worship, I am now in possession of the signed, commissioned affidavit. If I may hand it up, Your Worship.
We then proceed to read it.
Thank you, Your Worship. Your Worship, the affidavit is supplementary / replying affidavit in support of the application for bail. Reads as follows. I, the undersigned Julius Dr. Mkhwanazi, do hereby make oath and say that 1. I'm an adult male, the first applicant in the above matter, and the deponent to the affidavit in support of application for bail deposed to on the 23rd of April 2026, which has been handed up to this Honourable Court and marked as Exhibit A. Paragraph 2. The facts herein contained are, unless otherwise stated, or unless the context otherwise indicates, within my own personal knowledge and belief, and are both true and correct. Paragraph 3. I depose to this supplementary affidavit following the production by the state of an affidavit deposed to by one of the investigating officers, Silindile Mdani, which was made available to my legal representatives moments before the state proceeded to present its case in opposition to my application for my release on bail. I am advised that it is necessary to deal with some of the allegations raised by the state in such affidavit, which has been handed up to this court and marked as Exhibit C. 4. At the outset, I deny each and every allegation raised in the opposing affidavit insofar and as much as such allegations contradicts and or is inconsistent with my founding affidavit Exhibit A and this supplementary affidavit. I will seek the leave of this court to allow me to present this supplementary affidavit. Paragraph 5. Respectfully, the state, Mdinani, misleads the court in suggesting that I was in any way complicit in the deaths of several of the witnesses mentioned in Exhibit C. 6. Firstly, dealing with witness D, whom we know was Marius van der Merwe, the owner of a private security company. The following pertinent facts need to be brought to this court's attention. 6.1. A suspect, one Madi Pandile Soteni, a former South African Police Service officer, has been arrested by the task team involved in this matter on 14 March 2026 in connection with the murder of witness D, and is presently in custody and will appear in the Brakpan Magistrate's Court, where, according to news reports, he will make an application for his release on bail. 6.2. I'm not at all a person of interest in such investigation. 6.3. Witness D has made several written statements to various law enforcement agencies, including IPIT, and which statements include the annexure to Exhibit C, about my alleged involvement in the disposal of the murdered suspect's body on or about 14 April 2022. 6.4. I testified at the Madlanga Commission of Inquiry about my alleged involvement in the disposal of the murdered suspect's body. Briefly, I had been contacted in the early hours of the morning, roughly 2 to 3 a.m., by a well-known police informant, Jaco Hannekom, who conveyed that he was at the scene in Brakpan/Springs, where stolen goods had been recovered. I went to the scene and found a huge contingency of South African Police Service and EMPD personnel and vehicles, who appeared to have already seized control and management of the purported crime scene. I was irate with Hannekom at bringing me out at such an ungodly hour when law enforcement were already present and managing the scene. I left after a few minutes. I certainly was not at all involved in any of the criminal acts that witness D mentions in the affidavit annexed to Exhibit C. 6.5. Indeed, I fully cooperated with IPIT in the investigation of the murder and the police involvement therein. As a result, I also became privy to a statement made by witness D to IPIT. A copy of this statement is annexed marked SA1. I submit that a comparison of the two statements show material contradictions in the narrative of the same incident. These will be argued by my legal representatives, showing that the court can place little premium on the reliability and integrity on the account of witness D. IPIT also informed me that in further statements by witness D regarding the same incident, he again materially contradicted himself. The task team involved in the investigation in this matter, well known at the Madlanga Commission of Inquiry, the IPIT investigator Nomsa Masuku testified that witness D had submitted, ostensibly to IPIT, two contradictory statements about my involvement and presence on the day in question. 6.6. It is also widely reported in the media, and indeed in an interview with witness D's wife following his death, that he became a target after his involvement in illegal mining, commonly known as Zama Zama mining. 6.7. It will be argued that no premium should be placed on the allegations by witness D in the affidavit before the court. Moreover, there is not an iota of evidence that suggested that I was in any way involved in his murder. 7. In respect of the witness Willem Viandre Pretorius, contrary to what the state suggests, the witness committed suicide. 8. In respect of the witness Sergeant Koza, it is common knowledge, confirmed by the investigation into his death, that he lived in Tsakani next to a known drug den. On the night of his death, he had purportedly heard cries of help emanating from this neighbor, and on going to investigate, was shot and killed. The investigation, in which several suspects were arrested and then released, clearly confirms his death to have been drug-related. 9. As stated before, Jaco Hanekom was a known police informant giving information to both the South African Police Service and the Metropolitan Police, which he had been doing for many years, and expectedly would have made him a target to many people in the criminal underworlds. Indeed, in a statement by Witness D, which I have annexed here to, Witness D describes himself as an SAPS informer of ill repute. In the premises, I reiterate my prayer to be released on bail in a reasonable amount, coupled, if need be, with suitable and indeed stringent bail conditions. Your Worship, the affidavit of Witness D, the second one, is attached here too. I do not propose to read it out, Your Worship. As indicated, use and reliance will be placed on this affidavit in the address to Your Worship on the merits of this matter. So unless Your Worship wishes me to read it out, I just wanted to be handed in as an action.
I think it is part of the report, even if it is not written.
As it
Because
is.
it is annexed here, not
Yes.
as evidence, but for a specific purpose.
Indeed so, Your Worship. Thank you, Your Worship. I submit this will then be, as Your Worship indicated, Exhibit D.
D.
Thank you, Your Worship.
Mr. Mkhwanazi, will you stand up? You confirm the contents of this statement as well as being correct?
Yes, Worship, I confirm.
Thank you. This statement shall be Exhibit D in the earlier one reading to record and handed in by Mr. Helens shall be Exhibit E as the court has indicated.
This is yours.
Thank you. I take it then that summarizes the evidence from both sides. Address, Mr. Wilkins. I hope you are ready.
We're ready to address whichever one first.
We are ready, Your Worship.
Let's follow the sequence.
As it please the court, Your Worship. Okay. Your Worship, it is common knowledge now before this honourable court that the first applicant, or accused number 1, has been charged with 3 counts, and the 4th charge been added this morning prior to the commencement of these proceedings. Your Worship, if I may just briefly summarise the personal circumstances of accused number 1. He is a South African citizen. All of these are set out in the founding affidavit. Born and raised in Katlehong, Gauteng. He has resided at number 22 Eugene Marais Street, Alberton, for the past 7 years. This property is registered in his name. He has strong and durable ties to the Gauteng community, both familial as well as professional. He's the father of 8 children, Your Worship, 4 of whom, including 1 adult, reside with him at his house. He has a close and ongoing relationship with the other children who reside with their respective mothers, but towards whose maintenance he contributes. He's been employed by the EMPD since approximately 2003, when he commenced service as a cadet. It is now common cause that he had risen to the rank of a Deputy Chief of Police, that he holds a master's degree in public management from Regenesis Business School, and that he had attended further academic programs at Wits and Cape Town universities. His monthly net salary is approximately 65,000 rands a month. His primary assets include his house, valued at approximately 2.5 million, with an outstanding bond in favour of Standard Bank of approximately 2 million rand. His household effects amount to approximately 300,000 rands, and he has an accumulated pension benefit of approximately 7 million rand. Your Worship, if the accused should decide to abscond and not stand his trial, he stands to forfeit all of these assets. He suffers from type 2 diabetes, diagnosed in 2021, and is dependent on a regimen of chronic medication. In addition, he requires access to his attending physician, Dr. Kuni Venter, for the ongoing management of his condition. He has no previous convictions, no pending matters, no outstanding warrants, and is not subject to any protection orders. He cooperated fully with the police since his arrest on the 18th of April 2026. He holds a valid South African passport, which he is willing to surrender if that is the condition of bail. He has no relatives or close associates residing outside of the Republic, and he has indicated, Your Worship, and confirmed that he has no intention of fleeing, and that he regards the present proceedings as a vehicle by which he will be fully exonerated. He categorically denies any involvement in the offences as alleged. He has no prior knowledge of any corrupt arrangement and has not received any gratification from any person in connection with the events described in the charge sheet. His defence will be fully disclosed once docket access is obtained. Your Worship, he was suspended from the EMPD in November 2025 as is apparent from Annexure C. That attached Annexure B as the suspension letter, and for purposes of the argument, Your Worship, we refer, Your Worship, specifically to the letter of suspension, who said and stated at paragraph 5 thereof, you are not to come into contact with any of the City of Ekurhuleni's employees. I will address that, Your Worship, at a later stage. More specifically, Your Worship, it is a common cause in its trite law that the fundamental principle in any bail application is that in our constitutional democracy we should maximize personal liberty as far as possible. In terms of Section 35(1)(f) of the Constitution, every arrested person enjoys the constitutional right to be released from detention if the interests of justice permit it. It is common cause also, Your Worship, and generally accepted that the court will lean in favour of liberty and grant bail where possible, provided that the interests of justice are not prejudiced. Again, Your Worship, it is tried that every accused person is presumed innocent until proven guilty. And as quoted at the outset in Exhibit A, the court must not treat pretrial detention as anticipatory punishment, stated by Justice Mohammed in the case of S. vs. Atchison. It is so, Your Worship, that the current schedule that we deal with is a Schedule 5 offence. And this requires of the applicant to satisfy the court on a balance of probabilities that the interest of justice permit his release.
Before you proceed, earlier in the affidavit Exhibit A,
Yes,
it was indicated that you are not so agreeable to that.
indeed,
Now,
sir.
I am now making a concession.
We are indeed, Your Worship. This is a concession made. We agree that it's Schedule 5. Thank you. Your Worship, Your Worship is quite aware of the fact that what is required and the onus that is required placed on us is a balance of probabilities. But, Your Worship, the court must also evaluate the full matrix of factors set out in Section 60, subsection 4, paragraphs A to E. And critically, Your Worship, the court cannot refuse bail on the mere basis of a risk or a possibility that one or more of those consequences may result. A finding on the probabilities in this regard is required, Your Worship. In this regard, I refer to authorities with which Your Worship is undoubtedly acquainted. First case being Ace versus Diale and another, 2013, Volume 2, South African Criminal Law Reports, at page 85, a decision of the Gauteng North Provincial Division of the High Court, at paragraph 14, and S versus Swanepoel, 1991, Volume 1, of the South African Criminal Law Reports, page 311, judgment of the Free State High Court, at page 313, paragraphs D to F. Your Worship, and following on all of these authorities, it is so that unless there is a real and probable likelihood of one or more of the Section 40, subsection 4 consequences occurring, that detention is not in the interest of justice and that the accused must be released. Now, Your Worship, I do not intend to address Your Worship on the issues such as whether the accused constitute a flight risk or any of those other issues, seeing as the state had not advanced that in the opposition of bail. So I respectfully submit that it cannot be argued by any stretch of the imagination that any of the other aspects had been proven as being a real likelihood. And I respectfully then will proceed to deal only with the issue of whether the first applicant will interfere with witnesses and the investigation. Now, Your Worship, we respectfully submit that there are various reasons that militate against a finding that the first applicant will in any way interfere with the investigation or intimidate or interfere with any of the witnesses. Your Worship, the first is, and I respectfully submit that this is a very strong aspect to be considered, is the inherent improbability of the alleged conduct and the weakness of a state case. Your Worship, the relative strength of the state case and whether it's weak or not is a relevant consideration in a bail inquiry and should be accorded due weight. I refer in this regard to the State versus Koch, 2003, Volume 2, South African Criminal Reports, page 5, judgment of the SCA, at paragraph 15, as well as the case of S. Botha and another, 2002, Volume 1, South African Criminal Law Reports, page 222, SCA decision at paragraph 21. Your Worship, in this case, and I am going to rely on the judgment in Koch when I develop my argument to a great degree. I say that when the State has relied on a case that is so lacking in detail or persuasion that a court hearing the bail application cannot express even a prima facie view as to its strength, the accused must receive the benefit of the doubt. This was confirmed in the Koch judgment, Your Worship, at paragraph 15. Your Worship, I respectfully submit that the narrative of the State, as advanced in the charge sheet, is on its face inherently improbable. The events alleged concern the second applicant, who at the time was the city manager, or not quite the city manager of Ekurhuleni yet. He faced a routine speeding charge, Your Worship. Now, of significance, Your Worship, is that the preamble to the charge sheet does not allege, and it has not been disclosed until we received the affidavit in opposition of bail, after we had deposed to our affidavits, that the second applicant faced any significant legal consequences from the speeding matter beyond the payment of a routine fine. And I'm dealing now, Your Worship, just with the charge sheet and the allegations in the charge sheet. In the charge sheet, it is then alleged that he prepared a substitute to appear in court on his behalf, apparently in order to attend a CFO interview on the same date. Now, Your Worship, it is not alleged that the second accused decided to disregard the date or attendance from the court proceedings merely because he did not want to attend. In this regard, I refer, Your Worship, specifically to paragraph 2 of the preamble under the whereas on the second page, not the first page of the charge sheet. And I'm now referring again to the charge sheet that we were initially provided with, Your Worship. Your Worship, it says that on the 9th of March 2019, Kagiso Lerato, accused number 2, was arrested for speeding by members of the Boksburg Traffic Department and was issued with a notice to appear in court on Monday, 13 March 2019. And paragraph 2, it later emerged that accused 2 was scheduled to attend an interview for the position of Chief Financial Officer at the same municipality where the accused were employed. So, Your Worship, it later emerged that he was, at that time, on the 16th of March, required to attend the interview. According to the charge sheet, Your Worship, that is when the decision was taken, or the request was made for someone to intervene and to stand in his stead in these court proceedings. Your Worship, now with the greatest of respect, the charge sheet does not claim that accused number 2, by virtue of the fact that he required someone to stand in his stead, intended to get an unintended or a beneficial outcome of these proceedings. It was not claimed by the State, Your Worship, that the intervention by this person who stood in his stead and on his behalf resulted in another outcome than what would ordinarily have resulted if he had appeared. Now, Your Worship, today it would seem that the opposing affidavit, the state is trying to cure the defect in the charge sheet, in relying on the affidavit of one of the investigating officers. Where suddenly, Your Worship, a normal speeding fine becomes a transgression for which summary imprisonment can be imposed.
Can you just repeat what you've said?
Your Worship?
Can you just repeat what you've said?
Yes, Your Worship. What I say is that in the opposing affidavit, deposed to by one of the investigating officers, it is suddenly and inexplicably argued that a person who is arrested on a mere speeding fine will be subject to summary and direct imprisonment. And it is then furthermore also stated that, Your Worship, it was to prevent his fingerprints from being taken. Your Worship, now with the greatest of respect, and unless one believes in fables and in fairy tales, a person who had been caught in a for a normal speeding offence and released with a warning to appear in court does not face imprisonment. The normal option, Your Worship, is a fine coupled with imprisonment. Or, as might have happened here, an intervention might take place. But summary imprisonment, Your Worship, that is, with the greatest of respect, not normally an option. And Your Worship, with greatest of respect also, if a fine is imposed, fingerprints are not taken. We are not here, Your Worship, dealing with uninformed, ignorant laypersons who have no idea what is going on. We are dealing with someone who is the Deputy Chief of Police, as well as a very highly ranked manager in Ekurhuleni. Your Worship, it is inconceivable that people like the accused before court would not have instructed an attorney if they required a postponement or if they couldn't attend. And I was informed by a number of my colleagues, Your Worship, that if an accused person ever requires a postponement under these circumstances, that they are more than willing to undertake such an onerous task of ensuring a postponement for a fraction of the amount allegedly paid over, to wit 400,000 rands. Because, Your Worship, as is then conceded in the affidavit by the investigating officer, there was not even a fine imposed. And a person who allegedly stood in for accused number 2, and I do not hold any brief on behalf of accused number 2, but who allegedly stood in, paid 800 rand from his own pocket as a result of the intervention, and that he was required to attend certain programs. And Your Worship, the investigating officer furthermore claims that there was an agreement, or that money was to be paid. And I respectfully submit, once again, if one has reference to the charge sheet, that these two versions are irreconcilable. Your Worship, in respect of and in motivation, justification of this version, I refer Your Worship to count 3, dealing with the alleged corrupt actions taken by accused 1 and 2. And it says there, in that on or about March and April 2019, and at near Boksburg, accused 1 in common purpose with Tsotsetsi and accused 2 agreed to accept a gratification to wit 400,000 rands from accused number 2. And Your Worship, the significance of this is to be found in the fact that in counts 1 and 2, it is specifically stated that accused number 2 was arrested for a speeding contravention on the 13th of March, and he was to appear in court on the 16th. So, Your Worship, when one now comes and count number 3 says on or about March and April 2019, it follows as a matter of logic that this agreement to accept money postdates.
I think there may be something not so accurate with the dates.
Yes.
Because the initial impression at the beginning, paragraph 1, is that he was arrested on the 9th and then had to appear on the 13th.
That's correct. Sorry, Your Worship. The dates 9 and 13. So, Your Worship, it's quite clear that the state is in possession of those dates. If the accused, or if an agreement had been reached before the 13th, between the 9th and the 13th, either the 9th, 10th, 11th, 12th, or 13th, then surely the state would have said in the charge sheet that between 9 and 13 March, an agreement was concluded in terms of which accused number 2 would pay certain monies to accused 1 and Tsotsetsi. the fact, Your Worship, that it is stated specifically in count 3 that during March and April 2019 provides a clear indication that this agreement must have been entered into after the 13th of March when he appeared in court. And this, Your Worship, is in direct contradiction with the version of the investigating officer. And Your Worship, the fact that despite all of these, there was an intervention, and all these facts I've now mentioned to Your Worship, the state nonetheless alleges that this arrangement resulted in a cash payment of 400,000 rands, shared equally between the first applicant and Tsotsitsi. Now, respectfully, Your Worship, as the first applicant states in his affidavit at paragraph 28, this is notionally disproportionate and implausible on any common sense view. Your Worship, postponement under these circumstances would have been achieved very easily. And on the contrary, Your Worship, if accused number 1 was corrupt, it would have been more prudent and easier for him to have contacted the prosecutor and arranged for the matter to be withdrawn, or to make arrangements within the EMPD for this prosecution to be terminated, or take other measures that was within his control at that stage. Your Worship, so I respectfully submit that just looking at the case and the merits of the case, one must have serious doubts about the strength of the state case and the plausibility of the version as presented by the state. Your Worship, furthermore, as recorded in the first applicant's affidavit at paragraph 29, the case number 345 of 3/2026 confirms that the matter was only brought to the attention of the police in March 2026, some 7 years after the alleged offences on the 13th of March 2019. Your Worship, no explanation has been provided by the state for the extraordinary delay. The delay itself, I submit, militates against the state's characterization of the matter as urgent or serious in the context of bail. Separately, Your Worship, and without recasting this as a legal argument, the charge sheet pleads that the Section 4 formula, PRECA formula, that is for the prevention of corrupt actions, Your Worship, without identifying what official function the first applicant held that was relevant to the events in question, what official act he performed or agreed to perform, or what official information or material he misused. On the preamble's version, Your Worship, the first applicant acted as a private individual who sourced his driver to impersonate a colleague. that the state is unsure about whether the accused number one allegedly did this in his capacity as a public figure or a personal individual, Your Worship, is to be seen in the fact that he is charged with Section 4, which would find application if he was acting in his official capacity. And the alternative, Your Worship, is that he's charged with Section 3, which would find application in the event that he acted in his personal capacity. Your Worship, the evidential environment in this regard is very similar to that which was before the SCA in the matter of State versus Kok, where the SCA noted at paragraph 15 that the state had, I quote, played its cards singularly close to its chest, unquote. Resulting in a, quote, startling paucity of facts, unquote. And the SCA Your Worship, from the information provided by the state that we now have at our disposal, the likelihood is that the witness that the state will call and will testify, and the only witness that can testify, will be Mr. Tsotsetsi. He's not a disinterested, objective outsider, Your Worship. If he in fact testifies, he will implicate himself in criminal misconduct. He will be an accomplice witness, and his testimony will probably be subject to the provisions of Section 204 of the Criminal Procedure Act. Your Worship is better aware of than myself of the fact that a accomplice's witness or testimony should be treated with circumspection, and that it should be satisfactory in all material respects before it can be accepted. If one has regard to the improbabilities in the state case, Your Worship, that I've alluded to, I respectfully submit that any witness who attends to court and who tries to maintain the fallacy that he was requested to save a person's job when that person is merely charged with a speeding offence, or is his promising future, or his promising career, Your Worship, I respectfully submit with the greatest of respect that that is completely incomprehensible and improbable. Your Worship, now I respectfully submit that two consequences flow from all of this. The first is that the state case, resting substantially on the evidence of a single accomplice witness, is inherently fragile. Secondly, Your Worship, Tsotsetsi's status as a Section 204 witness will in all probability be the subject of a formal arrangement with the Director of Public Prosecutions. Such a witness's cooperation is governed by the terms of that arrangement, and it is not contingent on whether the first applicant is in custody or at liberty. The risk of interference with Tsotsetsi through bail is thus speculative and not probable. The fourth reason we advance, Your Worship, as to why the objection by the state is meritless, is that the investigation must be substantially complete or in an advanced stage. We submit this is the case because the investigation must be at a late stage, because the state was satisfied that there was sufficient evidence to prefer charges and justify an application for a warrant of arrest. Your Worship, an investigation that is sufficiently complete to ground an arrest, a warrant, and a prosecution on specific counts is an investigation that is no longer at a vulnerable stage. The concerns that attend bail in an early investigation, where information gathering is ongoing and witnesses have not yet committed themselves, do not arise with the same force once the decision to charge has been taken. Any reliance by the state on the risk of interference with the investigation in general, without identifying what investigative steps remain and what the first applicant could do to frustrate them, amounts to impermissible speculation. And I reiterate, Your Worship, the state did not take this honourable court into its confidence. The state did not indicate at what stage of the investigations we are. The state did not indicate what investigative steps remain to be taken, and did not indicate what the applicant could do to frustrate them. The state cannot, with great respect, request this Honourable Court to speculate on what they should do and whether there is, under these circumstances, a reasonable prospect that the accused might interfere with the ongoing investigation. And I, again, Your Worship, refer to the State versus Cock at paragraph 19, and I quote where the SCA said, quote, that certain witnesses had already committed themselves to the prosecution would, it seems to me, render it less likely that any attempt to influence them would bear fruit, unquote. If witness statements had been taken in this case, Your Worship, and a decision to charge had been made, the witnesses are already committed. The marginal risk of interference at the bail stage is reduced, not increased. Your Worship, if the state was serious in its opposition and wanted to indicate what steps could be taken by the applicant and how he could interfere with either the investigation or the witnesses, after we specifically denied that such steps would be taken, it was obliged to lead rebutting evidence, or at the very least place in dispute our averments by genuine counter-averments rather than mere accusations and speculation. Your Worship, I do not know if, I see it's already 3:30, I do not know. I see you, Worship.
When you see the clerk ending with this, she saluted me to that fact.
Yes, I thought it's, when I saw her handed up, I thought it as much, Your Worship. Yes, so.
It's now 3:30.
Yes.
And I get an indication that they are claimed at Kusimantu in Pretoria.
Yes.
So to do all the administrative work, get the J7s
I know.
signed,
Yes. I know.
get them processed and
Yes.
transferred,
Yes.
definitely need some time.
I'm quite aware of that, Your Worship. Yes.
I do not know how the commitments of the other members of the court is, but tomorrow I'm here as well.
I don't know how much further or longer my learned friend's going to be. It seems that he's not finished.
But really we are not going to finish today. If it is 3:30 and then he's busy addressing and then you're still going to have your turn, the prosecutor is going to have his turn, you are likely going to reply.
Most certainly we wouldn't get to the state today, and we are available tomorrow.
I think you are also available tomorrow.
I am.
Let's enroll the matter for tomorrow.
If my learned friend stopped now, I could finish by 4, but that doesn't finish the case at all.
Mr. Mkhwanazi and Mr. Ruta, would you please stand up? The case against you is rolled over until tomorrow for the continuation of these bail proceedings. You take remaining custody until tomorrow morning. Please stand up.
As a court, please.
Now we know what it is.
So that you telling me, I want to
Thanks for. Thanks. You are a seasoned court officer. Of course.